you probably saw this screen because it was stuck here. I'm just reiterating that I'm not providing any specific legal advice, tax or financial advice to you. This is a little bit about me, so you know who's speaking. I am a licensed attorney. I'm certified elder law attorney. I'm Ohio State Bar Association certified specialist in elder law as well. I'm also a VA accredited attorney and a CPA as well. So I think one important thing to point out is my why I got into this, why I work in elder law. That was my grandmother, and growing up, she lived with us, and when I was in high school, she was diagnosed with dementia, and then when I was in college, she had a stroke, and she ultimately spent 7.5 years in a nursing home. And throughout that entire time, my family was very unprepared. She didn't have any estate planning documents in place. So I saw what happens when a loved one has a health crisis and there's no planning to be done. And so I really wanted to get into elder law and estate planning to help many families kind of avoid what I had to go through personally and saw. So today I'm going to talk a little bit about elder law because not many people may have heard about it. And then we're going to talk about the big 6 estate planning documents, and I have them ranked as to what I feel their importance is. Some of you may disagree, but we're going to go through each one and kind of explain what it is and why it's ranked that way. So just starting off with a basic definition of elder law. There is a book called the Elder Law Answer Book, and it defines it. I'm not going to necessarily read that definition up there. I always like to say that it's an area of the legal practice that focuses on the needs of an aging population to ensure that older adults remain in control of themselves and their assets and remain as independent as possible by helping you prepare for a secure tomorrow. So sometimes I get asked, well, what would I come talk to you about? What should I talk to you about? You can talk to me about any of these items here. So it can be about your estate planning documents, your wills, your trusts, your beneficiary designations. You might come talk to an elder law attorney when a loved one is aging and they start needing more assistance, whether it's in the home or they have to maybe go into a facility and you're concerned about paying for that facility. Maybe there's questions about the contract that you're signing when you move into a facility. There can also be questions posed to me about veterans benefits paying for long-term care. If anybody has a blended family, maybe a second marriage, or if somebody is a single individual, and I hear many times from many single individuals, well, it's just me, so I don't really need the plan. And that's kind of the reverse. If you're single, you probably need to have more planning in place than maybe if you are married. But I can help with probate. If somebody's being taken advantage of or a victim of a scam, I can assist with that. And if there aren't any documents prepared, and now you're kind of in this situation where you're stuck, someone can talk to me about that as well. And also, if you do have a loved one with a disability, there is some special planning that needs to be done in that particular case. And so those are all the kind of different topics that an elder law attorney can assist you with. Why work with a certified elder law attorney? To become a certified elder law attorney, you had to have been in practice for at least 5 years. You had to take a full day exam. I've had to have a certain number of continuing education hours, specifically in elder law topics, and been peer reviewed. And I renewed my certification every 5 years. So it's kind of really honing in on the fact that I've had a lot of education in this area and take this area of the law very seriously. So jumping into the countdown, as I said, I work with a lot of people with estate planning, and one thing that I tend to hear a lot is, I'm not old enough. I'm not old enough to do an estate plan. So I'm going to ask everybody out there, and ask everybody who's in person here, who here thinks that estate planning is based on age or wealth? No, they're shaking their heads no. So that is kind of the correct answer, in my opinion. Um, Estate planning is about security. So I always like to ask, like, would you skip paying your car insurance? No, probably not. Well, I mean, other than we're required to have it for a license, but it's something that you would never think to just skip. So don't think about skipping having an estate plan. I oftentimes call it the best love letter that you can ever write, because it really is making sure that you're making it easier for whoever would assist you in the future. You're helping them out. Plus, I do like the phrase that we plan and God laughs, and there's accidents, there's unknowns all the time. So having an estate plan can definitely assist with that. And it's not just death planning. So I really tell everybody that any person over the age of 18 should have some sort of an estate plan. And maybe your estate plan will adjust and be different as you age, and likely it will. But start off with the basics, at least if you're 18. Another phrase, another quote, actually, it's from a show on Netflix called Sweet Magnolias. But the quote was, just because I have a plan doesn't mean I'm in a hurry to leave. So oftentimes someone will tell me, that they're scared to come visit and speak with me because something bad might happen the next day. And I'm here to say that hasn't happened for any of my clients. So, but what is an estate? A lot of people tell me, well, I don't have an estate. I don't have anything. What does an 18-year-old have? Well, an estate can include your home. It can include your car. It can include the personal items in your house. So your clothing, your collections, all of that. Your bank accounts, your investment accounts. Your estate does include your pets. They're considered property in Ohio. It can include things like, oh my gosh, I'm blanking on the word right now. Timeshares. That's what I was thinking of. Timeshares included can be part of your estate. So even if you are younger, you still have an estate, because likely you may have a vehicle. You probably have at least your personal items at home and have some thoughts as to where you would want those to go. And then as you get older, your estate grows as well. So sometimes people ask, should I go in alone? Should I do the online software? That was a particular Groupon ad that I saw that I just found kind of amusing. Reasons to do online: one, you don't have to leave your house, which is sometimes great, sometimes not. But they really say that it's convenient, but is it? Do you really want to take a crash course in the law? Maybe not. And then the cost. This is another quote that I really enjoyed. If you prepare your taxes and they end up incorrect, the IRS may end up working things out. But if you decide to do your estate plan by yourself, you're never going to know the result of your work, but your family sure will. So kind of, be a little bit wary of online. Maybe if you get some assistance and go to an estate planning attorney, you can actually get true legal help. So you're not calling a 1-800 number. You're not hoping that they answer, real life person there to answer your questions. And you do want to have detailed instructions to help avoid any kind of court involvement. So you want to make sure that the case law is appropriate in Ohio, the documents are appropriate for Ohio. And a lot of times people come to me and say, wow, we never knew we never knew that this was an option or something that we needed. So you're going to find out a lot more about the plan. And of course, you'll be starting to build a relationship for your family. So if they need assistance in the future, then of course they have someone to go to. So getting into the documents. Now I know everybody has heard that in life you need a will, and everybody kind of hears, I need a will and that's all I need. Well, I actually rank this last as the least important document. Now, why am I ranking it last? Well, probate means administering the estate of a decedent who died with or without a will. So even if you don't have a will, the Ohio laws do have a way of distributing assets. So it's not like if you have, nothing, that it won't be, it'll just kind of stop and be tough. There is a process. Will that process be annoying for your family? Yes, it will. So one thing that I do like to remind people is a will is merely a document that says how things should be distributed through probate. So a will doesn't help you avoid probate. It's just kind of speeding up some things and making that probate process a little bit easier. So probate, likely whoever is going through probate will need the assistance of an attorney, and attorney fees can be quite high. They're based on a percentage of the value of the assets going through the process. There will be court fees. There will be different petitions and forms and approvals needed by the court. Here's one thing that I like to point out a lot. Probate is a public process, so anyone can physically go to the court and examine the file, and many, many courts nowadays have online dockets that you can go and just look online and look at people's estates. And you may say, who in the world is going to care? Who in the world is going to actually go look at that? Well, guess who but scammers. So a lot of my families who have had to go through probate have told me that they've seen a big increase in the amount of spam mail, spam phone calls, all of that kind of stuff, because your name and address and phone number are then publicly listed. And they know, how much money you're now getting. Probate can take a bit of time. It could take anywhere from 6 months to a year. A lot of probate cases go on much longer than a year as well. So your beneficiaries won't get their money right away. And then it only takes one heir to not sign a consent form to suddenly make it a will contest as well, which means more hearings, more time involved. So probate is not super fun, and most people want to avoid probate. So like I said, the last will and testament really is just saying, here's how I want the probate process to go, which is why I put this document in as number 6. The provisions that you might have in your will could be saying who you want to have your distributions go to. So maybe it's specific people, maybe it's a charity. It's going to say how you want your personal property distributed. A will should always nominate your executor, meaning the person who's going to deal with the estate, and dispense with a bond. A bond is an insurance that you're not going to run away with the decedent's assets. You're going to follow the probate process accordingly and do a good job with it. There could be language written in stating that you want some asset protection for the surviving spouse or any children. There can be also provisions written in there to help an individual with a disability or minor children. And then a remote beneficiary means if something kind of crazy happens, where I always say, you and your loved ones are all on that boat and the boat sinks and it goes down at once, there's still a provision that says what happens to your estate. So it just doesn't go back to the state. And then a contest clause is a provision in the document that can say, If someone contests the validity of the document, they're kicked out, they receive nothing. It helps avoid any kind of fighting amongst beneficiaries. So why is this in last place? You can use beneficiary designations and you can use joint ownership or a trust to help avoid probate. So by using those items, you will not have to go through probate. Oftentimes a will is looked at after a death or memorial service. So sometimes the will might say, like, these are my funeral wishes. But if the document isn't looked at until after it's already occurred, then that's not really helping anybody. Again, the document nominates your executor. It's not like someone can take your will and then walk up to the counter and say, hey, I'm the executor. You have to actually go through that whole court process. And like I said, it's expensive, it can be timely, but you still may need a will as a backup. The document number 5 is something called the Declaration of Funeral Arrangements. So this is a document that says who has control of your body upon your death. So the same way you kind of assign someone to be in control of your personal property, you're saying, my physical body, here's what I want done with it, and here's who should deal with that. Now, it is definitely helpful if you want cremation because it allows one person to sign off on that versus like all of the family members. Obviously, as well, one thing that I like to encourage everybody is consider a funeral trust or a prepaid funeral because it again can make things easier for your loved ones. So some people may ask, what's the point of this document? There's no point. So I'm going to ask the live people here because I'll get a response. Does anybody know who that individual is on the screen?
Casey.
Yeah. So Casey Kasem, for some of you who may not know, Casey Kasem was a victim of elder abuse prior to his death. And I'll answer the second one. He's a very well-known radio DJ. Top 40, I think, was the show, yeah.
Ask us more here, we remember.
Hey, he was on Saved by the Bell. I remember. Does anybody want to take any kind of guess as to where he's buried?
It's not in the United States.
It is not in the United States. And that's my point. He is actually currently buried in Oslo, Norway, because of the elder abuse that was happening prior to his death. It kind of carried on after his death as well. And his wife at the time wanted to ignore the wishes of his children and everybody else that said he wanted to be buried in the U.S. And she wanted to be difficult, and so she had him buried in Norway. And a document like this can obviously help avoid that. If he had simply written down his own wishes, then all of that could have been avoided. So document number 4 is a living will. A living will is not the same as a do not resuscitate order. So a DNR is a medical directive. A living will is a document merely stating what your last wishes are. So it's only going to cover 2 scenarios, whether you're permanently unconscious or you're terminally ill. And it's going to say, if I am in one of those 2 conditions, I do not want life-sustaining treatment. I want to be permitted to die naturally with comfort care. So for some of you who may remember the name Terri Schiavo, it was a case out of Florida in the 90s, I think, and she didn't have a document stating what she would want to do if she were in a permanently unconscious state. So these documents can help, again, prevent fighting amongst relatives who might say, well, they wanted this. No, they wanted this. It's you stating exactly what you want. The third document on here is a trust. So this is just a fun fact. I find it interesting. Maybe no one else would. But trusts emerged from the time of the Crusades, where knights would leave their property with somebody else until they were done fighting and then come take it back. So the way I describe a trust is like a box. It's a container to hold your financial assets. So many of you out there may have had one of these when they were little, and you might have said, I put all my stuff in it, put out all my toys. And then you might say you took it everywhere that you wanted it to go. And lastly, who got to use it? The people that you said, people that you allowed. So a trust is kind of like that. You create your own box and you move your financial assets into it. And then the trustee, who is the person that the grantor appoints, then takes that trust wherever the grantor's rules said they wanted it to go. And then the people that get to use it are the beneficiaries. So in the trust document, it'll say who the beneficiaries are and who gets to reach their hand into that wagon and use it. So a trust, basic here, a trust can help you while you're alive, and it can help at death. And there are like two main overarching topics or types of trust called revocable trust and irrevocable trust. There are many different types of trusts underneath each kind of umbrella topic. And a trust is always created between the grantor and the trustee. And then you have three parties involved, though, the grantor, the beneficiaries, and the trustee. And it technically is a legal contract. And a trust likely would take the place of a will and have some better benefits associated with it. So sometimes people will ask me, what can a trust hold? It can hold all of your savings accounts, checking accounts, houses, investments, annuities, savings bonds. You may not want to put any retirement assets in a trust. The IRS will view that as a change of ownership and send you a 1099 for the tax. So probably don't want to do that. You may not also want to put your motor vehicles or boats or anything else like that.
I'm curious about that.
The boats or the motor vehicles?
Yeah, the motor vehicles like the RVs and boats.
Yeah. So sometimes with a trust, you may not want to put those in because especially if the purpose of your trust is asset protection, and then you put a vehicle in where there can be a lot of liability, you could potentially cause a car accident, someone could sue you. You don't want the other assets exposed to the liability of like the motor vehicle or something.
What about if you just had like a single trust for a single vehicle? I'm like, I want to have my buddy Bill use my RV.
I mean, you certainly could, but I will say probably the better alternative than setting up an entire trust just for one vehicle would be to do the transfer on death forms through the Bureau of Motor Vehicles. But great question. And then lastly, there are some specific trusts made for firearms called gun trusts as well. Do you have to be a millionaire to set up a trust? No. People set up trusts for many variety of reasons. It could be tax planning. It could be helping someone through a period of incapacity. Because when you have assets in a trust, it helps avoid the need for a guardianship. One of the biggest reasons is to avoid probate and allow for quick distribution of assets to beneficiaries. Some people are doing it for wealth transfers. Some people have very specific instructions that they want to include, and they want to make sure those instructions are followed. And then it could be privacy reasons. Again, avoiding probate helps with the privacy. It could be for asset protection. As I said, there could be a friend or a family member with a disability to setting things up well for them or working out any of the blended family issues that may come up. I want to be aware of time. So this, we may not be able to, I want to be respectful of everybody's time, so I won't go too deep into this necessarily. But you have a revocable living trust. The key thing about a revocable trust is I call it an open box. You can have full access to it. You can create it, you can be the grantor, you can be the trustee, you can be the beneficiary. It is the main point of a revocable trust is to avoid probate and provide a way to manage assets through a period of incapacity. So you don't have any kind of asset protection against creditors, but it does avoid probate. So this is probably the most popular type of trust that people do set up. Then you do have different asset protection trusts for either VA planning or Medicaid planning. I call this a closed box. You know, this is kind of an in-depth discussion, so I'm just going to say that there is a trust that can assist with that. They each have different time frames in which they need to be set up and funded. Funding means actually putting the assets in the trust and having them exist there. So this may need to be kind of a separate discussion, but I wanted to throw it out, these slides out for you. If anybody has additional questions on it, I'm more than happy to answer, but this is kind of almost a whole presentation in itself, just talking about this and why someone might do the Medicaid or VA planning. So the second most important document, in my opinion, is the healthcare power of attorney document. So a power of attorney document is you authorizing another individual to act on your behalf. Power of attorney documents are only effective up until the maker's death. So a lot of times you'll hear people say, well, I was the POA, why can't I do something after death? They're only good while somebody is alive. If you see the word durable before it, it means that the document should still be valid and survive through the incapacity of the principal or the maker of the document. And then any power of attorney document can be limited, and limiting means it could be limited for a specific purpose or a specific time frame, or you can have a general one that says, I'm generally granting all these powers to my agent. The purpose for a power of attorney document is to avoid needing guardianship in the future. So number 2 is the healthcare. This is a document where you are saying who you want your agent to be to make healthcare decisions for you. This document specifically says here in Ohio that it is only effective when 2 doctors have determined that you meet the criteria and a doctor needs to talk with your agent versus talking to you. It covers everything from hiring and firing doctors to accessing medical records, to picking up prescriptions. It touches on whether or not your agent can make end-of-life decisions for you. And it should definitely nominate who you would want to have be your guardian if you need it. Now, that may sound contradictory since I just said the documents are meant to avoid guardianship, but there are some times where people become so incapacitated and maybe they have an illness that comes with paranoia, and they may go in and verbally revoke these documents. And if that happens, but you still need assistance, then someone still may need to have a guardianship. So you still want to say who your own guardian should be. And I definitely say that everyone over the age of 18 should have this document. The reason why it's not in the #1 spot is the state does have an order of importance that they will allow your family members to make medical decisions for you if you don't have this document. But where this is important is if you don't want to follow that, the legal standard, and you want someone else to help you, then you need to have it in writing. So that slide was a little bit out of order. The number one document that I think is the most important for everybody to have is the financial power of attorney document. So this is authorizing someone to make legal and financial decisions for you. Now, oftentimes I'm asked, well, I'm married, so I don't need a financial POA. Or this person is on my bank account, so I don't need a financial POA. That is false. If you are married, the reason why this is number one is if somebody can't access your financial assets or engage in certain transactions on your behalf, they're going to have to get a guardianship. There's no set, with medical decisions it's different. If you don't have the document, they will talk to your spouse. With financial power of attorney documents, if you don't have one, nobody's going to talk to you. So even for married couples, there may be a lot of situations that come up legally that you still need to have authorized your spouse to act on your behalf. One question may be, do you want to make it immediately effective, or do you want to make it effective upon your incapacity? It may sound counterintuitive, but most attorneys do actually say that immediate authority makes more sense, because that way, when you need the help, someone is there. It could be hard to get two doctors to actually say things in a timely manner. A document can be revoked, but should last through a period of incapacity. And there is a big difference in financial power of attorney documents. There is a big difference in all of the documents that I talked about tonight. There's something called statutory powers, which means the powers that are granted under Ohio law, versus more of an enhanced document that might include more authority for your agent. I can tell you this, if somebody needs to apply for Medicaid to pay for, say, a long-term care facility, a statutory power of attorney document is not good enough. So you do need to work with an attorney who can help you include the language that would allow somebody to help you in kind of the most vulnerable spots you could be in your life. You also want to have protectionary language in the document. You don't want just your agent to run around and have complete free reign. And most importantly, are there successors named in the document? What is the backup plan? I see so many documents that only name one agent, nobody else after. If you don't have anybody else after and you lose your capacity, you're ending up in the court system. So those successors are very, very important. These are some of the standard powers in Ohio. I'm just going to kind of flash this up here. Some of the more helpful powers to include are powers to hire professionals. You still may want to give your financial POA the ability to access medical records. You may want to include caring for your pet, setting up trust, delegating authority, gifting. Self-dealing is kind of a questionable power, so that's always important to talk with your attorney about. These additional powers may require express authority. So what that means is if it's not written in the document, your agent doesn't have the ability to do it for you. So make sure that the document kind of covers a wide array of topics. And then this is where I'm located, and I thank you. And if there's any questions, I'm more than happy to answer. I know I ran through that pretty quickly, but.
What was the self-dealing that you mentioned there?
So self-dealing is a concept that means can your okay. Self-dealing means can your agent engage in transactions that they could also benefit from. So an example of that might be if you allow your agent to gift assets to someone, can they gift assets to themselves? Or can they only gift assets to, you know, someone other than themselves? So it's considered an important power because it also could be the most abused power. So great question. Yes.
Can we get copies of these slides?
Yes, I'm happy to provide those copies.
Where does like the transfer upon death happen and all those listed the 6 things that you had?
So, also a great question. The transfer on death is basically the alternative to the last will and testament.
Okay.
So it would be that you would put the designations on your assets while you're obviously still alive and able to do that. And then the designations would apply after your death, and each facility would have kind of their own way of dealing with those designations. But basically, it's usually presenting the death certificate for the individual, and then the assets will pass accordingly to those designations.
I see. But it's still a good idea to have like the financial power of attorney.
So the power of attorney documents are while you're alive. In my personal opinion, I find the documents that focus on alive but unwell to be the most important, because I mean, I don't mean to sound bad, but like when you are dead, like you're dead. It's not really gonna like hurt you. But it would make things more difficult for your family. But while you're alive and unwell, like if you don't have some of those documents in place, it makes it hard for you and your family. And so that's why I kind of put more importance on those documents.
Thank you. Thank you very much. That was a lot of good information. I also want to share this with the folks here. And if I'm awkward on here, I'm still getting used to looking at a little screen, but I like looking at you folks. So if I stumble and bumble, I apologize. But if this is correct, please feel free to reach out to this young lady, and she can even meet you at the credit union to help you. And there's other areas where she could help you if you're concerned about, losing assets to a nursing home and Medicaid planning. I mean, there's just a world of value right over here to our right, and in here too. But I want to verify this to you that I want to stress to you, the credit union really does care about your well-being. So to bring this type of service in to help you, and I'm really happy to be a part of this. And I just want you to know we care. Everything's not about making money. It's like help people. That's what we're all about, right?
Right.
And the last point is I can tell you over 33 years I've experienced people who had their legal house in order, which was beneficial and helped the family in cases where it hasn't. And you want to be on the area where you help your loved ones. Mm-hmm. But with that, if there's going to be more questions, we're going to turn over to Joel from Ash Brokerage. It's a brokerage firm that works with us on insurance products. So we have the legal planning, and then sometimes there's products that could be mixed in there that will help preserve some of your financial and your assets, et cetera, life insurance planning, et cetera. So we're going to turn over to Joel. This will be a little more brief. But please, if you reach out to this young lady, I don't know if we have your business cards or it's going to come up on the screen.
I passed out the business cards to the in-person attendees. And then we can go ahead and your email's up there, correct? Mm-hmm. My vision is so bad, sorry. At the end of the day, it's completely done. We have a telephone number and an email up on the screen, so please, you feel free to reach out to Erin directly, or you can reach out to myself or Kelly if you want to schedule an appointment here at the branch. And with that said, I'd like to introduce Joel. Joel, are you there?
I'm here. Can you guys see and hear me okay?
We can hear you.
Let's see, let me go to,
You learned something?
There we go. I got you up here. Okay, perfect. Yes, I can see and hear your presentation.
Great. And you can see the presentation on the screen as well?
I can. You haven't moved it yet, so I don't know if it's going to go with you from slide to slide, but from what I can see, it's on the OC Federal Credit Union.
And did it move there?
Yes, it did. Perfect.
Then we're ready to go. Well, thanks for having me, everyone. I've had the pleasure of being a part of 5 or 6 of these at this point, so it's good. It's good to be back. I work with OC Federal Credit Union and help with a lot of the insurance planning on the back end. Oftentimes, you all won't see me when you're working with Kelly, but I work with every single product creation company in the industry, and which is about 80 to 85 of them. And we're always in the business of making sure that we're putting you in the best situation possible that makes sense for you and for your family. I've been doing this for about 8 years now. Love every second of it. Got into it because my uncle was a actuary, and then he managed a team of about 30 actuaries at the time and was leading people and doing presentations to governmental boards on different rates and traveling. And then I realized that the majority of actuaries just work with stats, and I like the people side more. So I got into this business and got more of a consulting role, and now work with about 300 different offices across the country, anything from credit unions to large CPA firms, attorneys, financial advisors, you name it. Regional banks, I probably help work with them in a consulting standpoint to help with their insurance business. What I'm going to talk about today is, Aaron touched a lot on making sure that you have some sort of plan when it comes to your estate. I'm going to touch on how we can protect your estate. So many of you in this room have done such a good job of saving over your lifetime and are in retirement or nearing retirement or have loved ones that are starting to think about retirement. And I want to make sure that this conversation we use to make sure we teach you and educate you on how you can protect that nest egg, protect those retirement assets that you've done such a good job to accumulate. And as well as if there's assets that you don't plan on spending, how we can more efficiently transfer some of those assets to the next generation. Before I dive into a lot of the presentation, one element that we use to protect your estate is we refer to this product and this type of planning as we refer to it as long-term care planning. And I say long-term care, and a lot of people think nursing home. So to address that and just where does long-term care fit, there's 2 types of care that you receive. And, one of the ways is we think of healthcare, we think of Medicare, and that's hospital visits and skilled nursing care and your doctor's visits. What long-term care is there to do is if you have some sort of extended event and, you're in an assisted living facility, you're receiving custodial care, you receive at-home care, or you are in a nursing home. But you have a flexibility of where you were receiving care, and that's kind of the big difference between those two. But wanted to clear that up at the beginning. But I work with families across the country, and having a plan is important for them. Understanding that if you do purchase a long-term care policy, it's an insurance policy, and as we look at this industry, claim dollars continue to go up, the amount of policies sold continue to go up, and it has more to do with where cost of care is in this country than anything else. It's an industry where we've experienced over 10% inflation in the last 3 to 4 years. I help families determine how they can fund it, how they can pay for it, and just really the biggest thing that the credit union is looking for you to do is just have some sort of plan to make sure that you're taken care of, whether that's product wise or family member, what have you. But some stats that are always remarkable to me is this is in terms of billions of dollars, and numbers go back to 2023. But as of 2023, over $14 billion were paid out in claims for people to be able to receive care where they're comfortable at. whether that's the home or nursing facility or an assisted living facility. And to break that number down even more, we want to understand where claims start. Most of the clients that I work with, they want to receive care where they're most comfortable at, and that's at home. And it's no secret that when we're looking at this document of where do claims actually begin, almost 3/4 of it, 73% of claims start at home, 18% in the assisted living facility, and 9% in a nursing home facility. Which oftentimes when I'm in person and presenting, I'll ask, where do you think that claims start? And it's amazing to me because almost always the overwhelming number is for a nursing home. And when we talk about long-term care, I mentioned having a plan. There's a number of different factors to consider, and it's the emotional side of who's gonna help with providing the care. For any of you who have ever been in the position where you are a caretaker or you are a caregiver of a loved one, you understand the emotional toll that it takes on you, that it takes on the person receiving care, and that it can take on your family. There's the logistical side of making sure you have the coordination of the efforts of who's going to the grocery store, who's mowing the lawn, the logistical side of the small things that you might not think about when you're receiving care or providing care to somebody else. And lastly, there's the financial concern, which Kelly and I can assist with, and hopefully that can alleviate some of the burdens of the first two. And when we're designing a plan, one of the big things that we want to be cognizant of is what are we protecting? How long are we looking to protect the event for? What are you comfortable with? What are some of the or what have been some of the life events that you've experienced with family members? How long have they needed care? So understanding that we can design the solutions to fit you and your personal situation, whether it's a 3-year event or we're designing to plan for some sort of an 8-year event. If I told somebody that they were going to be in a nursing home for 8 years, they might not be happy about that. So don't get upset with me. But whatever it is, we can help with that design. And the other important element is how can we fund the plan? There's a lot of flexible funding mechanisms, whether you're doing a single premium or you want to be able to pay for the policy over 10 years and never have to pay a premium again in your life. Whatever it might be, we can help. There's other types of funding from other investments that you might already have. If you have cash on hand, obviously that's great. That can work. Cash value life insurance can work. Non-qualified annuities, qualified accounts. There's flexibility, is the point in me telling you all of that. And we can skip over this. I know we're approaching time. But the last thing I'll say in terms of the long-term care space is it's a big market that continues to grow and continues to be a concern for folks just of where cost of care is. And like I said earlier, many people that I work with, they want to continue to receive care where they're comfortable. And if we can help you do that and we can help you design a plan, the credit union cares tremendously about everyone on this call and everyone in the room. And that's what we're looking to do. So even if it's not from a product solution standpoint, if we can just help make sure that you're thinking the right way in terms of who's going to take care of me if I need it, or maybe you're thinking about this from a parent's perspective of how am I going to take care of my mother or father if this sort of an event occurs. That's what we want to make sure that we're doing. The last piece in terms of long-term care that I'll cover is what makes a long-term care event. If you or a loved one gets to the point where you cannot perform 2 of the 6 activities of daily living, that is where you can go on claim for your policy, or you can go, you can have one of your loved ones go on claim. So the 2 of 6 activities of daily living are bathing, dressing, eating, toileting, transferring, and then maintaining continence. So if there are 2 out of 6 of those that you or a loved one isn't able to perform, then you have access to the dollars from your policy. And then a lot of the solutions that we're seeing right now that are competitive in this evolving industry, usually you put in a certain dollar amount, and many times you're getting 3x the leverage on that money to be able to pay for qualified long-term care expenses. And if anybody wants to dive into that a little bit more, Kelly and I are more than happy to have that conversation. The last piece that I will touch on, I know I've got 2 to 3 minutes here, is just efficient wealth transfer. I won't go too far into the weeds on this, but when we talk about efficient wealth transfer, one of the most efficient ways to transfer wealth is using life insurance. We've done such a good job to accumulate wealth, whether it's in taxable accounts or whether it's in a qualified investment portfolio. It's part of a business. Wherever it is that you've accumulated it, are there ways that if you're not going to use that wealth while you're living, that we can pass that on to the next generation? And a great example of that is in many instances, if you have qualified investment accounts, those are not efficient assets to be able to transfer to your kids. So if we can handle that while you're alive, it makes that process for them that much easier. Similar to the story that Aaron was telling earlier. And at that point, once we've kind of figured out what assets we're going to help transfer and what's most important and how we can do it as efficiently as possible, is it the kids that we're looking to do the planning for? Is it the charity? Sometimes I work with families across the country and they don't have kids, but they just want to disinherit the government and make sure that the charity of their choice is getting the money, or they're funneling the money to where they want it to go. So whatever it is that gets you up in the morning, we can help with that too. And with that, I know